As you know, there is an awful lot of people who feel that these restrictions going into place in the first place, that the governor overstepped his bounds, that the governor did not have the constitutional authority to be able to put some of these bans in place. We had talked not that long ago, for example, with some of the folks who had defied the governor, opening up their places of worship, opening up their gyms. There's a number of people who are looking now to the United States Supreme Court. And what they want, so that it doesn't happen again in the future, is to declare the actions of the governor a violation of the Constitution. We have joining us now Attorney Mike DeGrandis of New Civil Liberties Alliance. And New Civil Liberties Alliance represents some of these local entrepreneurs and church pastors and school headmasters and others who have been opposed to this. And Mike, thanks for being with us.
Thanks for having me on.
Mike, give us a little bit of this. So for a lot of people, we have pretty short memories. Hey, May 29th is going to come along. The masks go away. We have a great summer. Everything's fine. You and the folks who are bringing this suit and want it to go all the way up to the Supreme Court, you're looking at not only what happened over the last year, but you're really looking to the future, too. Is that fair to say about what kind of powers the governor has?
That's right. I mean, I'm excited for Massachusetts. I'm originally from Pittsfield. I still have a lot of family and friends who live up there. And, it's really, really good news that the numbers are coming down, that the governor's opening up, that the governor says that he may even rescind the state of emergency declaration somewhere in the middle of June. That's all good news, but it's not good enough news. If the governor can do this during this pandemic, that is, shut the entire economy down, dispense with the law, in other words, to pick winners and losers by deciding whether it's their business or their activity is essential or non-essential. If he can do these things with this pandemic, he can do it with the next emergency too, and we have to prevent that from happening.
So, this was pretty unusual. This was a pandemic. To me, Mike, some of the conversations we've had over the last year, really, I think people have different ideas of what freedom is. To some people, hey, freedom means that I get to, don't tread on me. I get to do whatever I want. The governor can't tell me to wear a mask. Other people say, no. Freedom, means that absolutely the governor can tell you to do that because you're part of our community. And, part of our freedom and part of our duty to each other is to keep each other safe in times of crisis. So certainly the governor should have extraordinary powers in those times.
But that's exactly why constitutions exist, is to protect us in ordinary times and extraordinary times. And I will concede these are extraordinary times. But the Constitution was set up in such a way, Massachusetts Constitution, so that the legislature has the authority to pass laws. The legislature was in session the entire time. The legislature could have declared a state of emergency. The legislature could have perhaps changed the nature of someone's business license. The legislature could have done many of the things that Governor Baker did, but Governor Baker as a chief executive couldn't do that because that's law by executive decree. Now, to be clear, though, that's not really the issue we can challenge in the United States Supreme Court. Massachusetts Supreme Judicial Court has spoken on that issue. This is something I think the legislature should fix. I think there's a political solution to this in fixing the Civil Defense Act and how it operates so that aspect of this particular case doesn't happen again with the next pandemic or next emergency. But what we're challenging are those restrictions that directly impacted the First Amendment rights, so federal constitutional rights, the First Amendment rights to peaceably assemble, and the 14th Amendment rights to substantive due process. So these federal constitutional rights are the type that the United States Supreme Court might be interested in hearing, and those are the particular issues that we're trying to raise before the Supreme Court.
Yeah, so the governor then, do you think that you would be bringing this if it had been originally what it was supposed to be? Hey, listen, for a couple of weeks, the pandemic's getting out of hand. We're going to shut things down. And we just don't want to be overwhelmed at the hospital. At some point, it seems to me that during this, you had the mission began to change a little bit. At one point, it seemed as if what we were trying to do is we were trying to keep things shut down until we were going to, kind of stamp out the coronavirus. Or we were going to wait until what we have now, until we had the vaccine, and Massachusetts has been receptive to people getting the vaccine. If the governor had used his powers, but had used them for a shorter period of time, in other words, what you were just talking about, the legislature has the ultimate authority, but man, sometimes they just are so slow, and we needed action immediately. Would we still be doing this? I mean, is this he doesn't have the power to act at all, or does the length that he used his powers come into play?
That's a great question, and it's a little difficult to answer, only because it's a hypothetical. It didn't really occur, but there are a couple of practical problems with trying to challenge the governor doing that. So, in principle, no, the governor didn't have the authority. From my perspective on the Massachusetts Constitution and how the Civil Defense Act was supposed to operate, probably wouldn't even have the authority over a couple of weeks. But it wouldn't be possible to really challenge it over a couple of weeks. I think most people would be willing to look the other way, just as a practical matter. Say, all right, 2 weeks to flatten the curve. Because you're right, the legislature is inherently slow. If the legislature had instead used those 2 weeks to conduct hearings, to have epidemiologists testify, to better understand the nature of the disease, the problem perhaps with the Public Health Act, and maybe where it was lacking in being able to protect the health and safety of Massachusetts residents. Maybe they need to amend that. Maybe there is some assignment of responsibility that they could give the governor through lawful means by simply passing a law and giving him certain authority. All of these things would have been on the table, and it would have been very difficult to challenge the governor in such a short period of time. Putting together a lawsuit, getting plaintiffs, and just understanding the dynamics of the situation would be that if it was a couple of weeks, we would not New Civil Liberties Alliance, we wouldn't have been able to bring a suit even if we had wanted to.
Yeah, listen, I mean, you're the legal eagle in about, what you can challenge with the Constitution. I'll just give you an example of what we talked about and see if there's a way that you can kind of put that into, how that might work into the Supreme Court challenge. Because this is what, especially in the beginning, what so many of our listeners were upset about. It was just what they felt was the fundamental unfairness of it all. We heard from that poor guy who, I'm thinking of a bar in Leominster. He's out of business right now. I mean, some others were able to get aid, and thank goodness they're coming back. But, this guy went out of business because being shut down killed him. And in that call to us, what he said was, he goes, it's awful hard to be going to shut down my business today when I'm driving by Lowe's and the parking lot is full. He goes, I just don't understand, why one restaurant is open, or why one bar says, okay, I brought in the hot dog machine, and that town says, sure, that's fine. And, the city that I'm in says, nope, we're not going to allow that. You really are a bar. Mm-hmm. You're not fooling us with the food. And we heard that from multiple businesses, just people just angry about what they thought was the fundamental unfairness, that the governor had picked winners and losers, and the big box stores were going to end up being the winners at the expense of the little guy. Now, that was kind of the emotion of it. Does that play into the legal part of it?
It certainly does. What you're talking about there, so I mentioned we have a peaceably assemble where we want the court to review the peaceably assemble piece, but we also want them to review the substantive due process piece, and that's really what you're talking about there. And a lot of people hear substantive due process, and it's not really obvious on its face what it means, but I really think it's just simply the sort of pursuit of happiness that was in the Declaration of Independence. Pursuit of happiness is essentially substantive due process. So your right to earn a living, your right to work in the vocation of your choice, the right to marry, to raise your children, to be educated, to have your children educated in the manner in which you see fit, and to raise your children in that fashion. So all of these things, just what we do day in and day out, that's the substantive due process right. And what we're objecting to with the Massachusetts Supreme Judicial Court decision is that they used an extremely low standard in order for the governor's those orders that impact substantive due process, such as the closing of businesses and selective opening of businesses, which is a really good example, where he's picking those winners and losers. And what the Supreme Judicial Court said was that, it's reasonably related to public health, and this is a public health emergency. And so, though his orders do burden the right to substantive due process, it is still constitutional to do so in the interest of public health. And our argument before the United States Supreme Court is, hold on. You can't just so quickly be dismissive of substantive due process rights. You've got to really analyze these one at a time and analyze them with a much higher scrutiny, because to sort of shoehorn this concern for the virus and the need to protect public health, which there certainly was, and then just to say that we can then therefore assume that there is no significant infringement that would be unconstitutional just because it's reasonably related, that doesn't work. Almost everything is going to be reasonably related to public health. And again, this is why the legislature should have been dealing with this issue, because the legislature would be much more in tune with the people. The legislators themselves are much more responsive to the people. They get telephone calls, they get emails, they understand what their communities need, and they would be able to craft much fairer rules, regulations, and changes to existing law than a governor who just, not for any reason of malfeasance, not for any bad intentions at all, but because his office is ill-suited to issuing law by decree, it was doomed to failure from the start. It was going to be unfair.
Is there any difference, as you're talking about the First and the 14th Amendment? So the church pastor that we talked to, who, by the way, it seemed to me that once he joined a lawsuit, that all of a sudden churches got moved up, and I think the governor probably was taking a look at what was going on around the world and said, or around the country, and said, you know what? Okay, the churches have got a pretty good argument here, so they're going to be opened up. We talked to the guy who was getting fined day in and day out, and they were coming to shut off his water and electricity for having his gym open. Are those different, though? In other words, does a guy who owns a business, he owns his mom and pop store, the pastor of the church, the person who's in charge of the Catholic school or his private school, you seem to have those all together, but could those all be different? I mean, could the Supreme Court say, listen, in the case of a church, you're violating their rights, you have to have them open. In the case of the mom and pop store, no, the governor has the right to say that they need to be closed in a public health emergency, or it's to the law they're all equal and all the same.
That's a great question. Supreme Court jurisprudence would it states that certain rights are, quote unquote, fundamental. And in doing that, things like free exercise clause, you can exercise your religion as you see fit. The Supreme Court does prefers free speech. Those types of First Amendment rights in particular are considered fundamental. I will just say I wholly reject that. I don't think that any right is more fundamental than any other right. But this is where we get to these tiers of scrutiny. When a court analyzes deprivation of civil liberties, and so that's what we argued in this case. That's what we're going to try to argue before the United States Supreme Court. The court applies these levels of scrutiny, and I described a little bit how dismissive the Supreme Judicial Court in Massachusetts was of the substantive due process issue. There, the level of scrutiny is called rational basis. They said it just has to have a rational basis, the deprivations, to the purpose, which is public health. But our assembly claim, that's a little bit different. So first, I don't agree with that. I think you have to go to a much higher level of scrutiny, and you really need to more carefully analyze that. But because the right to peaceably assemble is a First Amendment right, this is a fundamental right according to the United States Supreme Court. And despite that it's a fundamental right, the Supreme Judicial Court in Massachusetts said, we're just going to use this intermediate scrutiny. just this middle scrutiny because we believe that the contents of the restrictions are neutral. And that's obviously not true on the face of it. If my business is essential and your business is non-essential, well, that is clearly not content neutral. The way that the Supreme Judicial Court justified that is they said that Governor Baker's goals were neutral, and that's just flipping the process and the steps of analysis upside down, and it creates this dynamic where when we divide up our civil liberties into buckets of fundamental or not fundamental, I mean, that is the first step to, and I don't usually like slippery slope arguments, but that is a slippery slope when we start splitting those apart. I think it's really important that we appreciate that just because someone may not be a churchgoer, it doesn't mean that they don't have an equivalent interest in perhaps their vocation or their business or in raising their children. I think that they're all equal. The court doesn't exactly agree with me on that.
Mike, this has really been fascinating. I appreciate your taking the time for us this morning. Before we let you go, tell us just quickly a little bit about New Civil Liberties Alliance, people who are interested in what you've been talking about this morning, how they can follow, and what do you think are your chances of getting this to the U.S. Supreme Court?
Well, as far as the chances are concerned, I'm hopeful because the Supreme Court has heard a few First Amendment COVID-19 related challenges. So I'm hopeful by the numbers. The Supreme Court usually grants about 1% of petitions for writs of certiorari per term, I should say. And so I think we've got a better than 1% chance, but it's tough to guess. It just depends on what the justices are interested in. The New Civil Liberties Alliance, just to describe what we do, we're a nonpartisan, nonprofit, public interest law firm. I think the best way to describe our mission is that we seek to relegate the administrative state to its proper place in the constitutional order of government. And that's really what we saw going wrong in Massachusetts with Governor Baker's Civil Defense Emergency Declaration. There, it's not an executive agency, but the chief executive himself was taking upon himself lawmaking power, expanding the scope of the executive beyond what the Massachusetts Constitution allowed, and doing it in such a way that infringed upon Massachusetts and federal constitutional rights of Massachusetts residents. If any of your listeners would like to follow what we do, they can go to nclalegal.org. That's one word, nclalegal.org.
Very good. Mike DeGrandis, thank you so much for being with us and talking to us about this.
Thank you for having me on. I enjoyed it.